as I said, criminal disclosure, practice, procedure and avoiding pitfalls, Friday the 20th of November 2020. So a couple of brief bios for Andrew and myself. As I said, I'm a senior associate at Sharp Pritchard. I do both civil and criminal litigation. It says here I regularly appear in a magistrate's court. Probably not true. I've not actually been in a magistrate's court since March this year due to the various COVID restrictions. But I have dealt with a wide range of complex prosecutions in the Crown Court as well, and lots of the disclosure obligations that arise from that. Andrew, as it says here, criminal barrister specialising in fraud, proceeds of crime and regulatory law. Listed in the Legal 500 as one of the leading junior barristers within their fraud section. And he regularly has a very heavy caseload of prosecutions for local authorities too. So you're in safe hands this morning, we hope. So it's going to be a presentation of two halves. I'll be going first, dealing with disclosure and unused material background law. And then the second half will be Andrew on how to manage disclosure effectively in all cases. So without further ado, disclosure and unused material for background law. So there's 7 areas we're going to cover this afternoon. A brief bit of background, the legal framework. We're going to look at initial details of a prosecution case, then primary or also known as initial disclosure and disclosure test. We're going to consider sensitive and non-sensitive material, the consequences of non-disclosure, and then defence, secondary and ongoing disclosure. So background. Fundamental starting point with disclosure really is that it all comes down to the rights of a defendant to have a fair trial. Now, there's various ways in which disclosure feeds into that. Obviously, there's a burden on the prosecution to prove their case. There's also an equality of arms that's required for the right to fair trial, and disclosure feeds into that quite clearly. And there's also the factor that a defendant needs to know and needs to have the ability to know and challenge the case against them, and defendant disclosure plays a key part in that. In addition, there's the right to silence and the right against self-incrimination, hence why there's no initial duty for a defendant to give disclosure or put forward a defence before trial. So there are 2 or sometimes 3 disclosure duties on the prosecution. There's the primary or initial duty, which applies in all cases. There's a secondary duty, which usually applies in either way cases, usually in the Crown Court, and once the defendant has served a defence case statement or provided some defence disclosure. And then there is the second or third, depending on which arena you're in, the ongoing duty as well. So let's look at the legal framework. The starting point, of course, is the good old Criminal Procedure and Investigations Act 1996, as amended by the Criminal Justice Act 2003, commonly referred to as the CPIA. There's the Code of Practice under Part 2 of the CPIA 1996. The current Code of Practice has been there for quite a while now, but there is a new version which has been published as a statutory instrument. It was published back in September, and that's going to come into force on the 31st December 2020. So well worth having a look at that. There's also the criminal procedure rules. Rules 8 and 15 in particular are of use for disclosure. And bouncing in from the left there, we've got the Attorney General's guidelines and disclosure. Again, those have been in place for a while now, since 2013, but there is a new version coming into force at the end of the year. In Andrew's slides, he'll be talking a bit about the consultation which led to the new guidelines coming in and some of his comments on that disclosure and the new guidelines. And then finally, there's also the judicial protocol on the disclosure of unused material in criminal cases, which I think is useful to see what the judiciary are being told to look out for on disclosure and the guidance that they're getting on it. So starting with initial details of a prosecution case. Now, I accept that this isn't strictly a disclosure obligation, but I think it's important to look at initial details of a prosecution case because that's your first chance to get material before the defendant. So Rule 8.2 of the Criminal Procedure Rules, as shown here on the slide. So it's a couple of key words to pick out here. The prosecutor must serve, so no discretion, initial details of a prosecution case on the court officer. I think it's interesting to note that the obligation is to serve the details on the court and to do so as soon as practicable, and in any event no later than the beginning of the first day of the day of the first hearing. Now, courts seem to vary in what they like and what their preferred practices are. Some courts, I think most of the ones we deal with in London in particular, they don't have any issue with you providing very large bundles of paper in advance, and they all seem to find their way into court by and large before the first hearing. Or of course, there are occasions where the material hasn't reached the court, and that causes all sorts of problems. But when I've prosecuted outside of London, in the southwest and in the home county, sometimes courts don't like you sending your initial details bundles in advance. Possibly their court offices aren't as efficient as they might be, and they prefer you to bring it along to the first hearing so that the legal advisor can take it and put it somewhere where it's going to be found for future cases. So it's all about knowing your court and knowing their preferred practices. And then 8.22, where a defendant requests those details, the prosecutor must serve them on the defendant as soon as practicable, and again, no later than the beginning of the first day the beginning of the day of the first hearing. And again, if the defendant doesn't request the details, then you still need to make them available to them, again, at the beginning of the day of the first hearing. So Rule 8.3 deals with the content of the initial details. Now, you probably all will be familiar with this, but I think it's worth going through them again and noting that they're not either ors. Everything here needs to be included if you have it. Summary of the circumstances of the offence. So I think quite often people will be in the habit of preparing a case summary, especially if you're dealing with summary only offences where you're hoping to have guilty pleas by post and you're providing a case summary so that the defendant knows the case against them and then can respond to it. You also need to provide an account of the given by the defendant in interview. Most usually, if you've done an IUC, this will be a transcript that's within the evidence bundle in any event. And then any witness statement or exhibit that we're going to, what we have available and we consider as material to plea or to the allocation of the case for trial. So really, the best practice here is to serve everything that you have. Again, defendant's criminal record, if any. I know a number of local authorities have issues with obtaining a criminal record. Some of you may be fortunate to have a court where you still have PLO sitting in court, in an office at court every day of the week. Some of you may even be lucky to have a helpful PLO sitting in court every day of the week who is prepared to dig out criminal records for local authority prosecutors and provide them, drop them into court for you. But it's not a given. Not all courts have those operating all of the time. And getting that information before a first hearing can be very tricky. I mean, it used to be the case, I think, where a lot of investigators were former police. They may still have contacts there. They can get the criminal record checks for you. But I think since GDPR, that stuff's very much been halted. So it's worthwhile speaking to your local force if you have any good contacts there and trying to get up some sort of data sharing agreement so that you can get criminal records checked in advance and serve them on the defendant, because there is, as it says here, an obligation to do so. And finally, then any available statements of the effect of the offence on the victim or the victim's family. So that's your impact statements if you have them. You won't always have those up front. Those may be prepared more for sentencing, but if you have them, you need to serve them. So moving on to the primary, or what's more commonly called the initial duty of disclosure, set out at sections 1 and 3 of the CPIA. Now, the initial duty of disclosure applies to any case where the defendant pleads not guilty to a summary only offence and the matter proceeds to trial in the MAGs. Also applies to a case against a person aged over 18 for an either way offence which is sent for trial in the MAGs, or a case against a person under 18 for an indictable only offence which is sent for summary trial in the youth court at the MAGs. While these rules generally only relate to proceedings coming to trial in the MAGs, if a defendant pleads not guilty and the matter is transferred to the Crown Court, these obligations also bite once the indictment is preferred or the matter is set down for trial. Now, sorry, I've got some notes here. Let me scroll through to those. It's worth noting that the timescales here, that in relation to when disclosure provisions bite in cases in the Crown Court have changed a few times in the last few years. So a number of years ago, it used to be that they would bite upon committal procedure, but with committal procedure having changed with the introduction of early guilty plea hearings, CPIA suggests that it's now only upon the matter being sent for trial, i.e. after the preliminary hearing or the PCMH, that the disclosure obligations will bite. That being said, a responsible prosecutor should be giving advance disclosure at an early stage, usually upon request by the defence. Typically because this will assist the defence with making a bail application, if that's relevant, making an application to stay the proceedings as an abusive process, if they're intending to do so, or an application that defendant should be committed on a lesser charge. But whilst I say it's good to give advance disclosure and to be helpful as much as you can, Of course, you don't need to be too helpful, and you certainly don't need to exceed the limits of your primary disclosure obligations when assisting the defence in such a manner. But it's all about really providing as much information for your own benefit, really, at an early stage. If you want your case to run smoothly, to make progress at each hearing, avoid wasted hearings, avoid wasted court time, then providing disclosure as soon as possible really has to be the best practice. So the disclosure test, what are you required to provide? So the prosecution should keep a record of all information gathered during the course of an investigation. If the material is going to be used as evidence to prove the case, this can be recorded in a schedule of used material. If the material is not going to be used to prove the case, then it must either be recorded in a schedule of non-sensitive unused material or a schedule of sensitive unused material, more on which to follow. And indeed, Andrew's got some useful guidance on keeping a disclosure log. Different officers in the investigation have different roles to play. Code of practice indicates such records should be initially maintained by the investigating officer or a specific disclosure officer. Now, I can't imagine many local authorities will have a specific disclosure officer. So usually this would fall on the investigating officer in the first instance. And the best practice is, of course, to start keeping these records from the start of the investigation rather than having to go back through everything and create your records afterwards. Little and often helps. The sensitive material schedule will not be served in the defence, but the non-sensitive unused material schedule will be. However, not all of that material in the schedule will need to be disclosed, if at all, and that brings us on to the test. So when complying with the primary duty, the prosecutor must disclose to the accused any prosecution material which has not been previously disclosed and which might reasonably be considered capable of undermining the case for the prosecution against the accused or of assisting the case for the accused. Or if you don't have any such material, give to the accused a written statement that there isn't anything that meets that description. So that's quite a finely balanced test, especially if you haven't had any indication from the defendant of what their defence is going to be, or the basis upon which they consider they are not guilty. Sorry, just going back a second. Let's check my notes, make sure there's nothing I wanted to add to that. No, let's move on to look at sensitive and non-sensitive material. Sensitive material is that material which is reasonably considered by both the investigating officer / disclosure officer and the prosecutor that it would not be in the public interest to disclose. Consideration should always be given as to whether any personal or other information which is of particular concern on the sensitive material can be redacted, with the remaining information which is then not sensitive being disclosed if it passes the test. Code of practice under part 2, the CPIA provides some useful guidance from para 6.12 onwards on the points to consider when assessing whether material is sensitive, so I'd certainly point you towards that if you have any questions or queries. Also, the CPS disclosure manual in chapter 8 is very useful as well, and I've provided a link up there on the screen where you can find it. But I think if you just Google CPS disclosure manual, that should bring you to the PDF, but that's a very useful document if you haven't already seen it. While admittedly it's not always immediately obvious whether a document is going to be truly sensitive rather than just being inconvenient or potentially embarrassing for the prosecution, the sensitive material schedule should definitely not be used to bury bad material. Always consider whether the material which may be sensitive can be redacted as shown on the slide so it can be disclosed. The code of practice and the CPS manual, whilst they're useful, a lot of the examples they provide relate to issues that are never really going to be relevant for a local authority prosecution, such as matters relating to national security, material received from foreign and domestic intelligence, and material that threatens national economic interests, whatever those might be in this day and age. So here are some relevant examples of sensitive material which it would not be in the public interest to disclose. So material that's been given in confidence, material relating to the identity, activities or private lives of informants or witnesses, especially anyone who may be in danger if identities are revealed. Again, it's not always relevant to most local authority prosecutions, but there may well be some trading standards cases where you're dealing with some aggressive characters. There could be neighbours involved, all sorts. So if there's going to be any concern about identities being revealed, or indeed threatening public confidence in witnesses being protected from intimidation and harassment, then that material does need to be kept out of disclosure. Again, material revealing techniques and methods relied upon in the course of an investigation. So any use of chises, things like that, or other methods for detecting crime. I know some councils have some quite useful surveillance techniques for monitoring fraud and other such things. So anything that reveal methods that are used should not be disclosed. Of course, material which relates to child or young person, this could be particularly relevant where you've got a test case for a trading standards prosecution, a test sale using underage individuals, then their identity needs to be protected, especially. And then material which may threaten the freedom of investigators and prosecutors to exchange views frankly about casework. Now, again, I think it's important to be cautious with this. If material only has cause to be embarrassing rather than to seriously threaten the ability of officers to discuss the case in emails and discuss the strengths and weaknesses, then really that material should go into the non-sensitive schedule. It's only stuff that really threatens the ability of investigators to discuss their views frankly. I mean, by way of an example, quite an overcautious view perhaps, but one officer I worked with previously took the view that to be only truly sensitive material in this respect is something that you would rather abandon the prosecution for than have to disclose. So if there's any material which both passes the disclosure test and is genuinely sensitive, i.e. it cannot be at all redacted, even partially, to remove any sensitive material, while still retaining the disclosable information which undermines the case or assists the defendant, then the only options are either to abandon the case or to make an application to court for a public interest immunity ruling, a PII ruling. So there are three types of PII application which can be made. First of all, and this is by far and away the most common, an on-notice application where the material is categorised and described generally, the application form served in the defence, and a contested hearing held in open court to decide whether or not the material should be disclosed. I mean, most commonly the judge would get to see the material in question, and your counsel or your advocate would make submissions on it, and the other side would have to make submissions on a more general basis, having been given a general description of the material. You then have an ex parte on notice application, where the application is served in the defence with as much information about the material as is possible without disclosing any of it, and where the defence are given the opportunity to make representations in writing in advance of the hearing, where the application is then heard in the absence of the defence. And then third, and by far the most rare, is an ex parte without notice application, where no notice is given in advance, where the matter is heard without the defendant present, usually before judge in chambers. So consequences of non-disclosure. If the prosecution fails to comply with their disclosure obligations, there are a number of potential consequences depending on the reasons for non-compliance. Firstly, and most seriously, the defence may raise a successful abuse of process argument at a trial, basically having the case kicked out entirely, which would be, whilst rare, you do hear of these things happening, usually not with local authority cases, but it can't be taken as a given. So it is, of course, very important that disclosure is dealt with properly. If a defendant is on remand, then disclosure failings can make the prosecutor unable to argue for an extension of custody time limits, if that's applicable. The defendant may be released from their duty to make defence disclosure. Costs may be awarded against the prosecution for any wasted time incurred by the other side through delay and non-compliance. The court may decide to exclude some or all of the prosecution evidence from trial if there has been disclosure failings. On appeal, a conviction may be found safe if disclosure of failings come to light after trial, and it's very worth bearing in mind that disciplinary proceedings may be taken against a prosecutor or the investigating officer for any disclosure failings. Sorry, bear with me. So, defence, secondary and ongoing disclosure. If your case is proceeding to trial in a magistrate's court, then there is no obligation on the defendant to file a defence case statement or give any disclosure of their own. While there is no obligation to file a DCS in a magistrate's court, the defence may, pursuant to Section 6 of the CPIA, opt to file one in order to trigger secondary disclosure, or just to put forward their defence in writing if they think that's going to be helpful for their case. They only have 14 days to file a Section 6 DCS as per Regulation 2.2 of the regulations under the CPIA. So it's worth bearing that in mind. These regulations here. So with the cases going towards trial in the Crown Court, the defence are obliged to file a DCS pursuant to Section 5 of the CPIA. They've got 28 days from primary disclosure by the local authority, to comply with that. Regulation 2.3 of the CPIA regulations on disclosure time limits is the relevant regulation there. So as soon as reasonably practicable, after the service of a DCS, the prosecutor must review the unused material again and reassess whether any of it now meets the disclosure test in light of the information contained within the defence case statement. An updated copy of the non-sensitive unused material schedule confirming that all the documents have been reassessed for secondary disclosure, whether any are now going to be disclosed, should then be provided to the defence at this stage. Similarly, if there is nothing further to disclose, then you also need to send a countersigned updated schedule confirming that you've checked everything again and that there's still nothing or nothing further to be disclosed at this stage. If you take the view that no further documents are disclosable, sorry, I've kind of been through this already, then the defence are entitled to make an application to court. Oh, sorry, I haven't been through this already, do apologise. If you take the view that no further documents are going to be disclosed at secondary stage, then the defence are entitled to make an application to the court for any specific items on the schedule to be disclosed if they think that the description given on the schedule suggests it's going to assist their case or undermine your case. And don't forget, of course, that even once secondary disclosure has been complied with, disclosure remains a continuing obligation. So if any additional material is received during the course of the case and the ongoing investigation, which is not going to be used at trial, then you need to subject it to the same test as above and ensure that the unused material schedules are updated accordingly and provide those updated schedules to the other side. So you need to think about this, I think, really in the same way as you would of if you get any evidence that you're intending to serve and rely upon at trial by serving a notice of additional evidence, then you need to, whenever any additional material comes, you need to look at it and say, right, what do we need to do to get this ready to go to the other side? What do we need to do to file this at court? So if you need to file a notice of additional evidence in order to get that evidence before the court, any further evidence, then by the same way you need to serve it on the other side. And if there's anything that you're not going to use that comes to light, you need to update your unused material schedule and serve it on the other side too. Sorry, before I finish, a couple of notes. Oh, getting ahead of myself. Ensure that I think really one of the points to raise here is that it has to be appreciated that disclosure is complicated and difficult, and it can quite often be a source of tension between investigating officers and prosecutors, especially where there's because the investigating officers gather material, but it's really the prosecutor's final decision as to whether any material needs to be disclosed. This can be a source of tension, so I think it's worth working closely with your investigating officers and make sure that they're keeping you fully updated with any material they're gathering and that they're keeping on top of maintaining schedules from a very early stage of the investigation. I know sometimes prosecutors, even in-house prosecutors, only get involved at a relatively late stage. So if you have departments that you work with regularly, having monthly or regular catch-ups at least to make sure you know what they've got coming through the pipeline and they can reassure you that they're doing their disclosure checks properly. All those sorts of things are going to be helpful in making sure what can be quite a tense relationship is managed as well as possible. So that's the end of my slides. Thank you for listening. If you've got any questions, we have got the Q&A open on the presentation, so please feel free to drop any questions in there. If there's been any questions during my bit here now, I'll have a look through whilst Andrew's doing his slides in a moment. You've got my contact details here. If you've got any questions that crop up, which you think might be a bit more in depth, or if occur to you after the presentation, then do please feel free to get in touch. We've got our banner spinning there for you as well. Okay, so I'm going to unshare my screen now, if I can manage to do that. And I'm going to hand over to my colleague Andrew, who's going to share his screen and share those slides with you.
Good afternoon, and thank you for attending this. It reminds me of the very beginning of lockdown when this kind of sort of seminar began on Zoom, which was perhaps more commonly used back then, of someone who in the course of one of these had forgotten that they had unmuted their microphone, and whilst in an event very similar to this, just sort of reached for their guitar and started strumming out a guitar solo for 15 minutes without realizing. And the only thing I can say is that I'm afraid this one doesn't have any musical accompaniment. You're going to have to put up with just me speaking. But we're going to go through what I hope is a very practical seminar about disclosure and how to manage disclosure effectively in all cases. I hope that you can see the slides on the screen at the moment. What we're going to just try and do is share some best practice from across the criminal justice system. I prosecuted in the past for the Serious Fraud Office, prosecute regularly for the Specialist Fraud Division of the CPS, as well as an array of local authorities, largely London local authorities, but a few outside as well, to really ensure the effective use of time, money and expertise. So hopefully this will be practical. I'm not really going to talk about the law, safe to say, something which Simon has already said, but I just don't think it can be stressed enough. It is the only thing in the criminal justice system that is referred to as the golden rule, and it's because bitter experience has shown that miscarriages of justice may occur where such material is withheld from disclosure. The golden rule is that full disclosure of such material should be made. So what we're going to talk about is really how the gathering, retaining, recording and revealing of all of that material, the GRRR, is done most effectively and efficiently. It's quite a broad range of material that may be relevant to an investigation. It's quite broad. It appears to an investigator or the officer in charge of an investigation or the disclosure of that it has some bearing on any offence under investigation or any person being investigated, or on the surrounding circumstance of the case, unless it is incapable of having any impact on the case. So it can be quite a burdensome task because it is so broad. I'm not going to go through any of the law. Simon signposted it. I have a slide where it's signposted. There it is. This part of the presentation very much assumes your knowledge of the disclosure process. And if you're involved in any case, in any criminal case, then you really must be aware of the fundamental basics that Simon has already gone through. The test that applies, as it's already been said, reasonably considered capable of undermining the case for the prosecution against the accused or assisting the case for the accused. I just throw in this case, Badgeresh Gohill, just as a little warning. In the case of Gohill, very senior counsel, QC and leading junior in a significant money laundering case. Mr. Gohill was a solicitor in Mayfair. He was accused of money laundering for a district governor of in Nigeria, a significant sum of money. And what the prosecution had begun to do was to view disclosure through their own prism. And the Court of Appeal, in commenting on that, said that the prosecution ought not to look through in the prism of their own case. There was a flaw in the approach of looking at it only from the Crown's vantage point. And so just a little warning that if you're finding reasons, if you're thinking of reasons about why something shouldn't be disclosed because the prosecution case is along these lines, then you may well be overthinking it, and actually disclosure ought to be made. And the reason why all of this sort of practical stuff is so very important is because mistakes continue to be made. There was a review of disclosure in criminal proceedings in September of 2011, conducted by Lord Justice Gross. There were then Attorney General's guidelines on disclosure in 2013. The Judicial Protocol on the disclosure of unused material in criminal cases followed very soon after. But then in 2018, because of problems, there was a National Disclosure Improvement Plan, and the Attorney General conducted a review of the efficiency and effectiveness of disclosure in the criminal justice system and found significant concerns with the culture around disclosure, engagement between prosecutors, investigators and defence practitioners, and the challenge of the exponential increase in digital data. And notwithstanding those measures taken in the last decade, 2011, 2013, 2018, those attempts still seem to have failed. The Court of Appeal caseload, which I looked at in the middle of this year, I suspect there's been precious little in the last 6 to 9 months, but in the short period before the summer in the past year, a litany of disclosure failures. In the Lady in the Lake murder case, failure to disclose expert opinion, ruling out a potential murder weapon, and material undermining credibility of a cellmate confession. In a drugs case, failing to disclose the transcript of an interview of a primary witness which conflicted with oral evidence given at trial. And in a separate drugs case, failure to disclose bank statements put to the defendant which showed a financial picture that supported the defence case. And despite damning failures of disclosure, no new principle, and in fact in most the conviction was upheld because the surrounding evidence didn't undermine the conviction. But enough examples to show that the system is still not failing. As Simon has rightly said, there's new Attorney General's guidelines coming in the consultation that was conducted in spring and summer. The Criminal Bar Association's response to the Attorney General's consultation. The barristers with their boots on the ground, seeing it playing out in the courts, was scathing. Basics lacking, both when it comes to investigators and prosecutors, and so there are efforts to change the culture. They've been growing in part in 2018, and they're accelerating perhaps now with these new Attorney General's guidelines, an approach described to be a thinking manner. Make of that what you will, but a thinking manner nevertheless. Rebuttable presumptions of disclosure and an emphasis on disclosure management documents, really front-loading the whole process as much as possible so that any problems are identified at the earliest possible stage. The proposed rebuttable presumption items include, and you'll forgive me, I think it's important still to share this. You will see that they are largely police orientated ones, but you will begin to think, I'm sure, of the cases, the type of cases, and we'll come on to it in a moment, the type of cases that we do in regulatory offences and local authorities. Equivalent examples. The list includes crime reports, investigation log, record or note made of contact with suspects, victim or witnesses, the defendant's custody record, and incident logs relating to the allegation, records from tapes and phone calls, previous accounts made by a complainant or any other witness, interview records, and any material casting doubt on the reliability of a witness. Now, one thing that's missing from that list, and it's still not in the guidelines, is body-worn video, now becoming increasingly common, obviously with the police, but also a lot of the local authorities that I work with utilising that kind of technology, and notwithstanding very sensible suggestions of that being included within the list, it looks like that element of the consultation hasn't been listened to. It doesn't seem to have been included in the final Attorney General's guidelines. In summary, the materials that feature on that list must be retained by investigators, must be scheduled, should be disclosed, unless they do not meet the disclosure test as set out in the CPIA. Where they are or are not disclosed, an explanation of the reasons why must be provided on the unused schedule. But very sensibly the case. Now, what is then a disclosure management document? We've looked at sort of the rebuttable presumptions. What is a disclosure management document? Can I just pause there for a moment, because there's a whole spectrum of local authority cases. They can extend to some of the largest criminal cases where very serious allegations of fraud are made, which have involved years of investigation, years of collating evidence and then prosecuting a number of defendants, where a huge quantity of digital material has been seized, and then there can be, at the very other end of the scale, someone who is selling peanuts in a tourist type location. Now there is such a spectrum. You will be able to judge. When I say that this seminar is about managing disclosure effectively in all cases, you will be able to judge that there are some cases where you just will not do this. But equally, I would encourage at least pausing for thought and considering whether it's worth creating a template which you can utilize not just for big cases, probably not for the small cases, but certainly for the medium cases, the run-of-the-mill case where a little tinkering, a little of that thinking manner, that horrible phrase, might just mean that actually it's worth doing. A disclosure management document should outline the strategy and the approach taken in relation to disclosure, and if so, should be served to the defence and the court at an early stage. It's suggested that disclosure management documents will require careful preparation and presentation, which is tailored to the individual case, and obviously that's a sliding scale of what degree of careful preparation and presentation you would need for a smaller case as against a far larger case. And both disclosure officers and prosecutors should be involved in that preparation. It's a living document. The best thing that's been said today is when Simon said little and often. When it comes to disclosure, doing it little and often will almost certainly make disclosure more manageable in nearly all cases. Little and often. It should be amended in light of developments in the case and kept up to date as the case progresses. Disclosure management documents are intended to assist the court in case management, ought to be served at the first significant hearing if it's a case in the magistrate's court, first appearance, Crown Court. If it's going to the Crown Court, maybe not until the PTPH hearing, but it should set out the prosecution's proposed approach to disclosure. The guidelines suggest that disclosure management documents may set out where prosecutors, investigators operate in an integrated office, an explanation as to how the disclosure responsibilities have been managed. And of course, that's particularly relevant with local authorities where it's likely that you are going to be in the same, broadly speaking, the same office. You're in the same organisation at least. And in the case of R, it was said that the prosecution must explain what it is doing and what it will not be doing at this stage, ideally in the form of a disclosure management document. And this document is recommended by the review in the protocol. It's intended to clarify the prosecution's approach to disclosure. For example, where search time, which search times have been used and why, and to identify the narrow issues in dispute. In respect of managing disclosure effectively, local authorities can develop their own disclosure management document, devise their own list of rebuttable presumption items, and challenge defence failure to engage. So what I would suggest with respect to developing your own disclosure management document, it can be tailored to local authority cases. It can lead to better defence engagement. It can be more cost effective in that way. There's surely a role for cross local authority collaboration. It's certainly something that local authorities in London, where there are agreements between them, have been interested in doing. And there is an example annex to the consultation of a disclosure management document. You can devise a list of rebuttable presumption items, an alternative to the police prosecution list things like company's house checks, planning history if it's a planning enforcement case, land registry checks, if it's a housing enforcement case, who the food business operator is. You will imagine that there are perhaps a checklist that can be devised for a variety of different cases. The investigation log, of course, and any council records that are held of benefits and or council tax registration, whenever that is important. I would suggest challenging defence engagement. It's underpinned by the criminal procedure rules. It's invited by the trial preparation form in the magistrates' court. I would suggest that adding at the end of the disclosure management document, inviting a response, giving a deadline by which you're inviting a response of search terms or what the defence issues are if they've been misunderstood. And equally at the PTPH and PTR, raising any failure by the defence to deal with disclosure, and of course challenging any defence statement inadequacy. And so that is, I hope, a sort of a whistle-top tour of disclosure management documents and the rebuttable presumptions, how to manage disclosure more effectively. I'll sort of leave my screen and see if there's any questions that have cropped up whilst I've been speaking, but those are my contact details. I'm happy to sort of receive contact directly if you want to ask any questions after today, and I hope that's been helpful, and I'll be pleased to answer any questions. And so I'm just going to stop sharing my screen